All right, thank you, Paige. I have the pleasure of kicking off today's final panel and acting as the de facto moderator. So we'll try to take on questions as well from the audience. I'll let my co-panelists introduce themselves because I don't have your bios in front of me. I apologize. But today we're going to be talking about the PMTA, obviously something that's been a hot topic throughout today. I have some slides here that are hopefully going to pop up. Oh, background. Okay, let me just back up a little bit. Okay, so we've touched on a lot of key points over the last couple of very informative panels and presentations, but I always think it's good to take just a brief step back and go through kind of the procedural history of to make clear how we got to where we are today. So with that, a little bit of background, which again, I am sure most of the people here are knowledgeable of, but for the benefit of perhaps a broader audience, just for a minute. So a tobacco product, right? We are here because Congress back in 2009 defined a tobacco product to be subject to FDA's authority. And a tobacco product, of course, is defined broadly as anything made or derived from tobacco. But at the time, Congress only gave FDA authority to regulate certain categories of tobacco products, so namely cigarettes, smokeless tobacco, and roll your own tobacco. In 2016, as we've heard throughout today, FDA extended that authority via the deeming rule to capture all products that met the definition of a tobacco product, namely novel products like ends and oral tobacco, things that we're focusing on today, to be subject to the Tobacco Control Act. And just recently, a couple of years ago, Congress acted again to amend the definition of a tobacco product to include not just tobacco-derived nicotine products, but products that contain nicotine from any source, the purpose of which was to capture synthetic or non-tobacco nicotine. So really what that comes down to is that today, everything that meets the definition of a tobacco product, any source of nicotine, nicotine salts, what have you, wherever it's derived from, is subject to the pre-market authorization requirements. So of course, this is a requirement that applies to all new tobacco products. A new tobacco product is anything that has been introduced or modified since the pre-existing or grandfather date of February 15th, 2007. And of course, with respect to the more the novel products, ends and oral nicotine, for example, heated products, those would be subject to the PMTA pathway, as opposed to one of the other pre-market pathways, such as substantial equivalence or the exemption pathway, which require comparisons to a predicate. So that category, those pathways apply to more traditional products. Now, we've heard about these dates and deadlines and compliance policies. There are a lot of dates out there. So for those of you who have maybe not been following this along for the last decade or so, very quickly, when FDA acted in 2016 to extend the deeming rule to all products, it created what we call a deferred compliance policy, pursuant to which products that were already on the market would be allowed to remain on the market subject to FDA or without the threat of enforcement. Because again, technically, all products as of the deeming date were illegal, right? Because they don't have marketing authorization. So that was clear from the beginning, and FDA decided that rather than try to enforce the entire market off the market or to potentially deprive adult smokers who were using those products to suddenly not have those, the FDA created these compliance policies, or really grace periods, to allow them to remain on the market for a certain number of months, or in some cases years, until a PMTA could be submitted. So we have these dates. August 2016 is the deeming date. January 2020 was the date that FDA modified its compliance policy for flavored pod systems. We have the 2020 PMTA deadline, which applied to tobacco-derived nicotine products that were currently on the market. Products that were subject to timely applications then had an additional year to remain on the market without the threat of enforcement. under the decision from the Maryland District Court. And then we have the synthetic nicotine products that came under FDA's authority in 2022. Congress established a subsequent PMTA deadline in May of that year, and again gave companies a very brief compliance window to remain on the market without the threat of enforcement until July 2022. So where does that leave us today? Today, FDA's position is that there is no longer a enforcement discretion compliance policy. All products that do not have a marketing granted order are illegal. So when we're talking about illicit versus non-illicit, it gets kind of confusing because the reality is nothing is approved except for the handful of things which we'll discuss today. But of course, as a practical matter, what does that mean, right? Because you go to any corner shop, you go to any vape shop, you're going to see many products on the shelves, right? FDA has limited resources, as Dr. King made very clear, and it must prioritize who it comes after. So it is looking at factors such as whether an application was timely, the current status of an application, whether it's potentially being used by youth, among other things. APPH is a topic that my colleagues here are going to dive into, but a couple things that have already come up in today's different discussions. This is the standard, right? Appropriate for the protection of public health that companies must demonstrate for their products. In my opinion, it's an even higher standard than the safe and effective standard for drugs, because not only are you looking at, in the case of a PMTA, the impact on the individual consumer, right? You're assessing the safety, the toxicology, you're looking at all those factors. You're also looking at and have to weigh the overall benefit to the population, right? You have to consider the risks and benefits to the population as a whole, both users and non-users, the potential for increased initiation versus cessation. It is a broad, multi-factor standard that requires assessing a broad array of different scientific disciplines. In terms of the PMTA process, boils down to three main phases: acceptance, filing, and scientific review. The acceptance and filing phases are intended to be more of an administrative, check the box procedure whereby FDA is supposed to look at an application, make sure it has all the basic information in the case of acceptance, and then allowing it to proceed on to filing, which is kind of like a preliminary scientific review. FDA is looking at whether there is product-specific data in an application, for example, and then ultimately, the way that it's supposed to work is that a filed application will then go on to the full-blown scientific review, where all the different divisions within the CTP Office of Science are looking at the application and making a scientific assessment. So what products have been authorized? As we've heard today, there are 23 tobacco with respect to ends products, 23 products, but really boils down to 6, right? 6 devices and their refills that add up to, I guess, a total of 23 authorizations, all of which are closed system, all of which are tobacco flavored, all of which are currently manufactured by large tobacco companies. That is the universe of non-illicit products that you're looking at here. In terms of non-ends, we have a few other PMTA authorizations going back to 2016 in the oral category, number of products that have been authorized in smokeless tobacco, for example. Heated products, we have authorizations for the IQOS, and of course, even in the combustible category, the low nicotine cigarettes have obtained MGO status. So what about all the other products? Well, we keep hearing that FDA has denied 99.9999 X percent of applications that have been submitted so far, and I think 100% of the applications for synthetic nicotine now have been reviewed. But just to dive in a little bit deeper as to what exactly is happening here for a second. So of those not tobacco-derived nicotine products subject to the original September 2020 application, the vast majority of those were able to get through acceptance and filing. unless you made a mistake of not including an environmental assessment. At the time, FDA was more routinely allowing applications to proceed into actual, well, what we thought was actual scientific review. But then when FDA got there, for reasons we'll get into, I'm sure, there was a policy change from our perspective, from the industry's perspective, with respect to flavored products that resulted in basically all of them being denied. So 1.2 million non-tobacco flavored products were denied for not having what is known as the fatal flaw review, for not having a very specific type of robust scientific study in the form of a randomized controlled trial or longitudinal cohort study assessing the effectiveness of a flavored product relative to a appropriate tobacco flavored product in terms of adult benefit, in terms of are adult smokers going to reduce their cigarette consumption or effectively quit more effectively with a flavored product versus a tobacco flavored product. That test, right, is now called the comparative efficacy test. And so what FDA did in starting the summer of 2021 was start to deny these applications in mass for not including that particular type of study. So instead of moving a filed application on to scientific review, where you would expect to get a deficiency letter, expect to have an opportunity to address FDA's questions, it did not get there. FDA did a check the box review of the application, looking for the presence of that particular study. If it wasn't there, regardless of anything else that was in the application, it was denied. Then you have the synthetic nicotine situation, where a lot of companies, because of those denials in 2021, began transitioning to synthetic or non-tobacco nicotine, because at the time, those products were not subject to the PMTA process. They were not made or derived from tobacco. And so for the nearly 1 million applications that were submitted covering millions of products, the vast majority of those have been refused. So those applications are not getting into, for the most part, into scientific review. And what's happened really since then is we had the PMTA final rule, which became effective in, I think, November of 21. And FDA has some additional criteria for acceptance, and they are really going through these applications with a fine-tooth comb. So if you're a small business and you made a mistake, and it's not just small businesses, it's large companies too, but if you use the wrong form, right? FDA often routinely changes their forms and their bundling spreadsheets, for example, on their website, and may or may not make an announcement about it. If you use the wrong version of a form, your application got denied. If you fail to include a letter of authorization that referred to a master file, a tobacco product master file, even if FDA had in its possession that letter in the master file itself, it was denied, or it's being denied. And God forbid, if you worked with a Chinese company, if there are any characters, any Chinese characters anywhere on the application that are not directly associated with a certified translation signed by a translator that has proper qualifications, it will be denied. So that is how we are getting to this situation where nothing is getting through, right? Even companies that have put significant effort, and I'm not just talking about the small manufacturers who just put in something to get something in. Companies have put in millions of dollars worth of PMTAs, and they make a mistake like ones I just mentioned. They're not getting through, they're getting denied. So it's very frustrating from the industry's perspective. I'm sorry, this slide is hard to read. It's getting kind of hard to fit all the recent MDOs onto a single slide, but I mentioned here since 2022, we have not had a single MGO. Here are the more recent MDOs that appear to have been mostly products that have gone through scientific review. So not necessarily talking about products that have been subject to the fatal flaw, but are still getting through deficiency letters and getting denied for various reasons, including menthol products, which appear to have been subsequently brought in under the kind of the comparative efficacy test requirement. So in terms of the PMTA MDO challenges, there have been dozens of challenges filed in court. Under the Tobacco Control Act, Section 912, a denial, so an MDO is permitted, an application that has been denied can be challenged directly in a circuit court, so an appellate court. You can go straight to the Fourth Circuit or Fifth Circuit if you have a denial. That doesn't apply to refusals, right? So if you get an RTA or an RTF, now suddenly, okay, even if it's for a reason that you think is arbitrary and capricious, you can't go straight to the appellate court. You have to go either administrative, file a 1075, or if you choose to seek judicial relief, you have to go through the district court. So you have to file an actual lawsuit, go through a trial in order to get, to the position where you can maybe appeal that, to a higher court. There are cases in the Fifth Circuit and others where companies have challenged their RTAs. But again, that might be one reason why FDA is currently focused on finding ways to refuse applications and not allow them into a place where they can be denied. So with respect to the denials, the MDOs, briefly, there are the main arguments that are being made in these lawsuits is that FDA acted in an arbitrary, capricious manner in violation of the APA, primarily by not reviewing the applications, right? So if FDA implemented the fatal flaw approach and did not actually consider the merits of an application, arguably that is an arbitrary and capricious action. That FDA did not provide companies with appropriate fair notice of this new comparative efficacy requirement for that specific scientific study. Another big point in these lawsuits is that FDA effectively banned flavors, a de facto flavor ban, and avoided the notice and comment rulemaking process. I see some chuckles in the audience. I'm sure that's a point we're going to be talking about the next couple of speakers here. The fact that FDA is requiring what appears to be effectively a smoking cessation standard, right? I mean, by this whole comparative efficacy, if you just think about how convoluted this is, these are companies and products that are not allowed to market themselves as smoking cessation products, and yet the standard effectively is, are you helping adults quit more effectively than another product? And so again, there seems to be something that doesn't quite jive there. Challenges in the courts, well, the vast majority, I think I'm missing a couple of circuits here, 10th Circuit and others, have sided with FDA, right, and effectively have given FDA the green light with respect to its fatal flaw process. But most of those applications are failing because they were not, in some ways, the courts are saying that the applications were not robust, right? Even regardless of the fatal flaw, FDA would have denied the applications for not having other evidence that would be required. And so it's really a harmless error, harmless, for them to deny at this point. It doesn't make sense to vacate the MDO for something that would be inevitable. It's a question whether that's the appropriate, position for a court to be making. But there have been a handful of, or I should say 3 circuit court decisions that have ruled in favor of the industry. I'm going to focus on the last 2 here, Wages and White Lion and Triton versus FDA. This is the famous case that was one of the first MDO challenges in 2021, where the Fifth Circuit granted a stay of the MDO in that case, and that's the language, that the surprise switcheroo that the court used to describe the sudden change in policy to require the comparative efficacy study. After that stay decision was issued in 2021, the merits panel actually held in favor of FDA. The company then sought an en banc review before the entire court. And that decision came out in January of this year, and was quite an interesting opinion. It's not often that you get Romeo and Juliet quoted in an appellate opinion. But the court held that FDA did not give appropriate fair notice of that study requirement for the non-tobacco flavors and did not acknowledge that it changed its position with respect to those flavors, that FDA ignored the serious reliance interest that these companies relied on FDA's pre-MDO guidance documents, on FDA's public meetings and statements, and in many cases, individual meetings. Companies had pre-meetings with FDA, and this requirement for this new randomized control study or longitudinal study was not mentioned, right? It was not an issue. And so, and then subsequent attempts by FDA during the litigation to argue that it in fact did review some of these PMTAs and marketing plans, the court wasn't buying it. And so quickly here, because I'm running out of time, the opinion is quite interesting. It really goes through how the FDA over the last decade plus kind of went back and forth and never quite, as we've talked about today, gave clear instructions on what it was looking for, and that's where we are today. There's also this really interesting footnote where the court essentially calls out FDA for violating rulemaking, right? It says FDA unquestionably failed to follow the notice and comment obligations before imposing its de facto ban on flavored e-cigarettes. That's the second time the Fifth Circuit, at least, has essentially called FDA out on a violation of notice and comment rulemaking. The first was in a stay decision for the Views menthol products. And so that remains to be seen whether that will become an issue for the Supreme Court, which is now potentially looking at it. And just briefly, we focus on flavors, obviously, but being tobacco flavored is by no means a guarantee of FDA authorization. We are seeing FDA issue MDOs for tobacco flavors. And the case I wanted to mention here is a DC Circuit opinion on the Phantom My Blue tobacco flavored pod, where again, we're not dealing with a fatal flaw. We're not dealing with a comparative efficacy question. This product went through the scientific review. The company responded to a lengthy deficiency letter. And despite those responses, the FDA still had some lingering questions that the court described as highly technical. So these are technical questions related to, the toxicology or certain types of studies that were conducted. And the court vacated that MDO because the FDA failed in its view. If you look at the technical project lead memo and other evidence in the record, FDA failed to perform a holistic public health analysis, which kind of sounds like the APPH in the first place. But the court basically said FDA cannot deny tobacco flavors for highly technical reasons without a balance on the public health grounds, without considering, well, if these are tobacco flavors and we don't have a youth issue, and we know that they're being used by adults who are smokers or could possibly go back to smoking, then now the court is saying, you, FDA, need to do a better job of weighing the overall public health impact instead of denying it based on highly technical questions. And so my final slide here is a list of pending Supreme Court or cases that have now been appealed to the Supreme Court. The first three, Lotus, Magellan, and Logic Technology, are appeals by the companies who had their MDO challenges denied by the Third Circuit, the Second Circuit, and the Ninth Circuit. And then we have the FDA, the Wages and White Line case, which is the en banc Triton case, where FDA has now appealed. Right? So FDA is seeking review by the Supreme Court of that decision. And there has been several amicus briefs that have been filed. I know the company in the Logic case has filed an amicus brief seeking and arguing that the court should take up that opinion because, as well as their own, which theirs is focused on a menthol product, a menthol e-cigarette. So, so far we are just kind of in a wait and see mode to see what happens with the Supreme Court. I think we'll probably hear before the end of the current session whether they will take one or some of these cases up. So with that, I pass it on to my next panelist.
All right. Normally I like to walk around and move a lot while presenting. So this is going to be really hard just standing still here. Hi, everyone. I'm Jessica Zdinak. Oh, no, that's okay. And Chief Research Officer of ARAC, a behavioral science research firm supporting the tobacco and nicotine industry, as well as medical device industry, and hopefully at some point soon to be cannabis industry. So I'm going to focus a lot of the conversation from a consumer standpoint and also primarily from a scientific standpoint. Excuse me. So I'm going to start with the current state of the market. Sorry. The implications of that state of the market for public health. What ultimately do consumers want? Why the MDOs, how we got here, and how we should move forward. So I think we've already seen this today. The current market state, really no flavors have been authorized. We have the ends products, the 23 we keep talking about. I do want to call out, though, the Verve. We did have the mint flavored oral nicotine products, even though they are not, see, not heads nodding, but they are not on the market. So the reality, even though we see that there are no flavors authorized, you go into practically every city anywhere, not really your big, big chain stores, but other stores, and you're going to find flavored e-vapor, e-cigarette products, as well as flavored other types of nicotine products. So what does this mean then when we talk about APPH? What does this mean when we talk about the public health? Right. And so the FDA has been granted the authority, as we all know, to basically authorize or deny with the standard of appropriate for the protection of public health. Okay. So keeping that in mind. So where we are is we have a flooded market of illegal products. And we've been talking about that a lot today. These products are untraceable, untrackable. You cannot verify that they are even produced and made from the manufacturer that we think makes them. So when we talk about public health, we should be really concerned about not just the fact that the FDA has not authorized flavored products yet, but what on earth is what's in these products that consumers are picking up and using. So we have then also a black market. It just screams illegal all over it. So there's a huge market of these flavors. We see a lot of instances. Obviously, we've all known who've been in the industry a while, the various reporting of illegal and illicit vapes being seized. And once you start to review the contents of those products, it's not good. And again, it goes back to because the flavors have not been authorized. What we do know, though, in the center of this is the consumer. They love flavors. So when flavors that maybe they once were using and were verifiable to some extent from from a manufacturer, now they don't have that, but they're still seeking it because they still want and crave the flavors. This is just another example of these implications of how many counterfeit and illegal vapes there are coming into the country, and then obviously then being sold. Okay, so what do consumers want? So in our organization, we meet with thousands of smokers primarily, but also other nicotine and tobacco product users. And we talk with them face to face. We talk with them about what they like, how to get them to stop smoking. And these are just two quotes that we pulled from recent research with smokers. And so you can see directly from their mouth what they say. With these flavors, there's so many flavors that you can use. I want the apple, but then when I'm sick of the apple, I'll take the lemon, and you have options. These are individuals who have quit smoking with flavored products. We also actually, this was recently, it's actually pretty funny. This woman was in the what we'll call, a tobacco focused condition or group. And she looked right at me and she said, "So I'm going to be getting this tobacco flavor this entire study. Because if so, I don't think I'm the right person for your study," because she didn't want to continuously come back and get tobacco flavored. It'll be interesting to see, we won't ever probably identify that person's data, but how her trajectory of smoking cessation occurs in the study. And then on the bottom, we're showing graph charts. This was actually presented at the recent Tobacco Nicotine Fiddly conference here. And what you're seeing in blue and orange is a comparison of cigarettes per day and a reduction of cigarettes per day in participants, smokers specifically, who were randomly assigned to either a tobacco group or a flavored e-cigarette group. And you can then also see kind of just the different visuals of that and the reduction over time. And this is kind of typical when you think about how manufacturers will report out their data, especially when we're talking business to business and wanting to make business decisions internally. But we're going to talk in a few minutes about the implications of that. So, also sharing data from a study of ours, the flavored group basically, had a 41% reduction in cigarettes per day from baseline to a month 3 follow up. The tobacco group, who only received the tobacco e-cigarettes, had a 24% reduction of cigarettes per day. So, when we think about the implications of public health on the current status of the market, which has no authorizations of flavors, in my opinion, coming from a consumer and a smoker standpoint to try and get them off the deadliest product possible, flavors tend to have an impact. So, why the MDOs? And we could probably sit around and have a lot of great conversation over this for hours from each of our individual perspectives. For me, and I know our team, you know, this is where we kind of turned then to the science. And not from a legal standpoint, not from an industry business standpoint, and really, honestly, not really from the FDA standpoint. We're an independent third party research organization. So when the FDA says they evaluate PMTAs based on this public health standard, it's considering the risks and benefits. And I know Azim was getting to mention that earlier. And then applicable to the population as a whole. So the benefit, you're always going to, in my opinion, have to demonstrate that smokers are going to switch to your product. Then you have on the flip side of that the risk of your product, right? And this is in the likelihood that youth or non users will start using that product. And yes, over time, as society changes, as social norms change, that risk benefit ratio is going to change. So we listened earlier about the significant reduction of combustible cigarette use with youth. That is occurring because the social norm of that behavior has changed in the United States. And so, again, we're going to then see a shift in different behaviors because of that. So, when we look at these MDOs, why, right? I just pulled out some quotes here. The applications do not contain evidence from a randomized control trial or longitudinal cohort study regarding the impact of the ends on switching or cigarette reduction. And that is in bold and underlined because that's really, really important. As a behavioral scientist, social psychologist, this was day 1 of 8 years in a career that they tell you when you need to assess the impact or the effect of a variable on an outcome, that is a randomized experimental study. We can call it randomized control trial or the comparative efficacy. I would even say it's not efficacy. I know that's the drug terminology in pharmaceuticals and stuff, but it is the effect of. And so inherent in that is going to be a design that controls for all potential confound variables that could potentially otherwise contribute to your outcome. And so we're going to get to the fun part of identifying reliable and robust when it comes to that. And then just again, other reasons for the risk side of things when they start to see obviously an increase in youth use. So what we do know based on FDA's feedback, meeting with the regulator, they want to see a rigorous scientific framework. And I could probably spend all day talking about each of these different circles here, but this is a glimpse into what rigorous and we're getting ready to talk about reliable means that we've interpreted and had meetings with the agency, with the regulator to, flesh this out and have conversations about what they mean. And so for a long time, it was, okay, what does reliable and what does robust mean? I think a really important point here as where that came from was this difference between basic social and behavioral science research. We're talking like module 6, switching studies, human factor studies, and TPPI versus applied social and behavioral science research. So I was in academia for a little bit, and so are some of the scientists on the team. Research that T-Course does, that academia does, is so different than what industry and private companies do. So when we think about lab research, And then we think about, okay, true applied research really focuses on in the real world companies, but industry is somewhere in the middle because the regulator is asking you for the standards that the basic social and behavioral sciences are conducting in TCOR and academia, tobacco control. But then they're also asking you to be able to generalize to your population. So there's, we have internal validity and external validity, super geeky words. And industry almost has this I don't want to say impossible, but a really difficult job in this space because they have to have both internal validity to say your methods are rigorous and reliable, but you also have to be able to generalize, right? And say that smokers will switch to this product. So it's a tricky place to be. Ultimately, looking here at what does it mean from a technical standpoint. So the FDA has made it very clear. Yes, they did call out randomized control trials and longitudinal cohort studies, absolutely. But when you really dig deep into it, as we have, it really comes down to they want to see a reliable and robust study conducted. What does reliable mean? So first, um, we use survey measures, right? So we have various constructs, we have various variables that we need to measure related to public health. They want to make sure, rightfully so, that the questions you're asking and the surveys that you're asking, that you can repeat them over and over again. You have reliable measures that will translate over and over and over again so that it's not just a one-time single phenomenon, random occurrence. Um, and in fact, so my colleagues and myself have started there with behavioral intentions. So with the TPPI, identifying psychometric analyses that support those TPPI switching studies, so that we know when we're measuring behavioral intentions, risk perceptions, that we truly are measuring those variables. This is a direct, correlation with, like I just mentioned, error. So you can't have results that generalize to the population that then gives you population health, right? If you have a study with questions and measures that have so much measurement error in them, and I know that if some people are just like, oh my gosh, this is so much fun. So it is essential in any measure you're employing in your study that you have those reliable measures, and the FDA knows what you measured is what you intended to. It's a pretty basic point. Robust. Okay, so this is when you have a survey design that generalizes to the broader population. This is then at the foundation, of this is inferential statistics. Descriptive statistics, descriptive results do not allow you to infer or generalize to your population. When you start dealing with power, p values less than 0.05, confidence intervals, various statistical aspects, that's what they want to see to say robustness means you can take your survey results and apply them outward. And so, where do you get this? You get it from experimental research. So, when they said randomized experimental or randomized control trial, what they're meaning is they don't want descriptive research. They don't want correlational research. They want an experimental design that allows for controlling potential variables outside the variable that you're measuring in hand, which, for example, might be flavors versus non-flavors. Okay, so that's a lot of that science background. When we think about then where we are with the market and the lack of flavors being authorized, we think an area that can be improved is in those inferential statistics. And so again, this was another study's results that we presented last year's Fidley. They're looking for statistically significant effects or differences. And so for this, those slides I showed previously were descriptive results. That's not going to be how they interpret reliable and robust to be. So this right here was a Mancova multiple analysis covariance. And this is examining whether or not flavored, those participants who were in the flavored condition above and beyond chance were going to switch to or significantly reduce their CPD compared to those in the tobacco group, in which it was some great results. So how we got here, I think, we could talk all day. Again, each of us has an individual perspective as to how we got here. I think we're here And I tell my kids this all the time and they don't listen, but I'm like, okay, now that you know better, let's do better, right? Um, and so I think that's where we're at today. So I guess when Azim was talking about the timeline and when the FDA started reporting out their expectations for these types of studies, whether it's the randomized, clinical trial or randomized experimental study, you know, okay, like it kind of sucks, right? Because it is a really reliable and robust and it's a big effort to conduct these studies. But now that we know it, let's do it, right? Like let's give them what they are asking for in hopes again of drawing in more flavored, more just essentially tobacco nicotine products to be authorized. And I will kind of end with the path forward. I think specific to the behavioral sciences, I just go back to the statement of when you know better, do better. And so, giving them what they're asking for, as much as it might seem unreasonable to us at the time or when it was coming out. And again, we're not involved in the manufacturer's, legal situations or the business objectives and how where we are today you know, how you guys got to where you are today. We're looking at it just from a scientific standpoint and making these recommendations, to give them what they're asking for. And I think that's a song, isn't it? And so with that, I will end and thank you so much. And over to you now, Clive.
Hi, everyone. My name's Clive Bates, counterfactual consulting based in London. I'm former director of Action on Smoking and Health in the UK. Also a civil servant. I used to be in Tony Blair's strategy unit, and I also used to be head of policy at the UK's main environmental regulator. So I'm a connoisseur of dreadful regulation. My objective today is to leave you even more angry about FDA than you already are. And I think I've got some fairly good stuff to show you. Okay, the first thing I'm just going to say why I think that there's going to be trouble in the courts for the foreseeable future. And this will particularly ramp up if we move on, if the courts and the litigants move on from purely procedural matters to substantive matters and have the ability to challenge FDA's reasoning. For example, if there is a change in the approach to Chevron deference, for example. Okay, so I'm going to go through seven main reasons that I think articulate what's wrong with what's going on here. So you're all familiar with this. Does anyone know what that equivalent number is for the European Union? Have a guess. All right, I'll spare you. 300,000. Okay, it's 300,000 vaping products in the common entry gateway for the European Union. The difference is it has a standards and notification regime. You basically have the right to put the product on the market if it meets the requisite standards. And therefore, nobody has to say yes, which is what regulators find hard to do. They have asymmetric risk aversion. Okay. Now, but that's not actually what we have in the US market. As you all know, there are thousands of products in the US market. And I don't agree, actually, Jessica, that they're terrible products. These are products that are coming out of an innovation engine in China that is quite unbelievably powerful. It's like a Formula One racing engine. It's highly tuned to what the consumers want and want to buy, okay? And whether it's the products themselves or ways round regulation, they are meeting the consumer demand, and that's why these products are successful in the United States. People want to buy them. Unfortunately, the American businesses, the law-abiding American businesses, are all trapped in a kind of creative sinkhole, justifying products that are 8 to 10 years old, basically obsolete in the market, to meet arbitrary, capricious, changing, opaque standards that FDA sets. And that's what's draining the energy out of the US business and leaving the market open to innovative Chinese companies, okay? FDA's massive barriers to entry here, the MGOs that have been granted have been $10 to $100 million, or some of the PMTA applications, $10 to $100 million. It's not that these smaller companies don't have products that are appropriate for the protection of public health. They just don't have the volumes, the revenues, the scientific capacity, the fat balance sheets to cross-subsidize with that the successful companies have. Okay, their products are just as appropriate for the protection of public health in the literal meaning of it. They just don't have the money to surmount the barriers to entry. Next. Opaque success criteria. You're all familiar with this. I'm going to dwell on this. We've moved from a kind of very, very generalized thing now to quite a specific test, which is this comparative efficacy test, which I think, to be honest, is quite difficult for most companies to meet, because most people don't just buy one flavored product and use it indefinitely to the exclusion of everything else. It's not that people just use one product. They use a diversity of products, and that they may change the product that they use in between the morning and the evening, depending on the social setting. Over time, they may enjoy experimentation. It might be the diversity of the products that is what gives the greater efficacy. It's also a slightly ludicrous thing, because these are recreational products. They're there to meet the demand for nicotine in a way that is less hazardous than using cigarettes. Okay, they're not there to be smoking cessation products, and there's going to be an increasing number of people who've never smoked that use these products. So how does that comparative efficacy standard work for them? FDA is not even bothered to be clear about how much more efficacious it has to be and how they will evaluate the results of the type of trials that Jessica was deciding. So it's still just as opaque, arbitrary, and capricious as it ever was. It's just that a higher, more difficult, more awkward standard has been put in place to sort of roll the ball forward further. Next, everything in the Act is contingent on the measurement of appropriate for the protection of public health. But who can actually explain what that even means? Okay, what does that even mean? Okay, now, the Act gives you some clues. It basically says, you've got to look at what the changes are in use, who takes things up, who quits, and so on. That's fair enough. Okay, but let's look at this grid here. Let's say there are some negatives and there are some benefits, and these apply to adolescents and adults. Okay, that's my way of conceptualizing sort of this here. So, okay, first of all, adolescents who would never have smoked, never have used nicotine, take up vaping. How bad is the harm to them? Actually, it's not very bad, because the harms are like 30 years away. You apply discounting, they disappear into the sand. Adults, adults who take these up, well, maybe they're just former smokers who like nicotine. They're not going to be harmed very much. Okay. Benefits to adolescents. Brian King simply rules these out. Kids who vape instead of smoking, that's a massive win in public health terms, but FDA has simply ruled that out completely of any consideration. There's nothing in the law that allows you to do that. The APPH standard doesn't stop at 21, and then a different standard applies below 21. He just says, no, I'm not doing it. But that's him and his preferences. Okay, it's not what the law says, and it's not what public health would say. And then finally, gigantic benefits to adults who quit, because they are the ones who are in imminent danger. There's many more of them, as I'll show in a minute. There's many more of them, and they're in imminent danger of getting these severe diseases, cardiovascular, lung cancer, COPD, stroke, and all the rest of it that you know about. Because that's likely to happen soon, in any evaluation, that would ring very large. Now, the interesting thing here, I've just put up that simple framework. What are these sort of exchange rates between the different blocks in that chart? How much is one additional net youth vapor worth compared to one adult who quit smoking, who wouldn't otherwise have quit if there wasn't any vaping available? What's the exchange rate? Does anybody know? Has FDA ever said? No, they haven't. Okay, now you could do this. You could use something like quality adjusted life years. You could make an estimate of how much the qualities vary according to a pathway that changes, and you could do an estimate. And I tell you, if you did do that, everything would be dominated by adults. Everything would be dominated by adults. You wouldn't even get a signal on the APPH calculation if it was down to youth. Okay, let's look at it. Again, I mentioned, they've done the usual thing with my slides, make them all unaligned, but that's good. You know, roughly speaking, there are 15 times as many adults in play in the United States, okay? And so when the policies are configured around youth, okay, they're missing the main issue, which is the people who are smoking and dual using, who are affected by policy. So when Juul had its marketing denial order, that's 3 million adults at the time, one estimate, that were using those products. Who, when they did that, what did FDA? How did FDA estimate the impact of its decision on those 3 million? What happened to them? What did they expect to happen? I mean, luckily, Juul challenged it in court and nothing happened, but they could have caused a catastrophe there. You know, and again, another question is, what if, you know, the anti-tobacco organizations, Campaign for Tobacco-Free Kids, Truth and everything, are always saying, well, clear the market of the products that aren't aren't authorized. Well, what if you actually did that? It would be a catastrophe for public health. 18 million people, only 1% of whom are using the authorized products, would suddenly have no vaping products to use. So, you know, be a huge public health problem. We have to be thankful that illicit trade is keeping those people supplied, which is an absurd position for a regulator to be in. Okay, naivety about youth. So all of FDA's reasoning is contingent on a model of youth risk behaviors or youth vaping, okay? The trouble is, there's a large number, and the most frequent users of these products, the more committed users, these are kids who would otherwise be smoking, okay? Now, when they switch to vaping, there's a huge benefit. They are diverted away from a life course of smoking. FDA simply rules that out. It's completely naive. There's another view of this. This is an overbusy chart, but this shows the segmentation of vaping use between vaping and smoking as it changes from 2014 to 2022. But I'm just going to compare 2014 to 2022. Here we go. Okay, so I've got rid of all the middle bars. That is an unbelievable success, okay? That is an unbelievable success for vaping, okay? First of all, look down here. The smoking and vaping, 70% reduction in smoking and 80% reduction in exclusive smoking in that 18 to 24 age group, okay? Then you look at this, did not smoke before vaping. These are people who are not smoking, but going straight to vaping, okay? But they would have been, in 2014, these people would have been smokers and they would have been nicotine users. FDA's totally not got its head around that. And it's a really, really important characteristic of the market. Right, de facto standard setting. Okay, here we've got, this is a flavor wheel just to sort of give you some sense of what the flavors market is like. For some reason that no one can really explain, FDA has decided that the tobacco flavor, which is a flavoring like any other, it's a bunch of chemical ingredients, is the sort of bellwether and the anchor against which everything else should be compared. Completely arbitrary choice. It's done because tobacco flavors are less popular amongst youth than other flavors. But so what? That's true for adults as well. And if you got rid of all the flavors, the other flavors, which is basically what FDA is doing, then the young people would either use tobacco flavor or they would smoke. There's no reason to assume that they would simply, you know, give up vaping and smoking and take up the violin and do more homework. Instead, it's just absolutely no evidence for that whatsoever. Yet that assumption is hard-coded into FDA's belief system about this. And I think, as others said, I'm not going to dwell on it, the decision-making, the way the decisions are made individually on product by product, but using the same comparative efficacy standard and fatal flaw approach is creating a de facto standard, whatever they say. And that's because it's very, very hard to meet that standard. And if that's what you have to do, then you're going to get a de facto standard. This is a little thing, but it totally bugs me. Assessing products in isolation, okay? So there's a huge market and there's your new product, okay? So FDA says, well, you can't put that on the market because, you know, it's flavored. Okay, so what happens? The people who would have bought that product just buy the next flavored product along, whether it's from a legal manufacturer or an illicit import. You cannot look at the population of effect of you know, a product going onto the market without looking at the whole category, the whole thing. You just can't do it. It doesn't make any sense because each product is just a marginal addition to the marketplace. You say, okay, I'm going to protect it with, I'm going to age protect it with Bluetooth. Okay, that's another thing that's coming up. It's not going to work because the kids will just use the products that don't have Bluetooth. You know, it's not going to make any difference to public health. Anyway, I'm going to round up now. Poor market surveillance. Essentially, FDA has no idea what's going on. It requires surveillance from the companies that have PMTAs. Okay, so it gets to know a bit about what's happening with them. But the real action is going on in the 99% of the market that doesn't have marketing granted orders and isn't directly under their control. But what it needs to do is understand what that market looks like. And it doesn't. It doesn't know. It doesn't know how to use its powers and to act effectively in that marketplace. So here's my summary slide. This is the kind of situation we're in at the moment. As you can see, it's not totally constructive and not likely to end well. And I've got 3 very quick comments to make. We should have a more standards-based approach, and I call them soft standards, comply or justify. So they're not like proper tobacco product standards. We should do all the population-based stuff should be done post-market, following, you know, proper surveillance and evaluation. Possible to do it in advance, but correcting stuff that's going wrong after market is a much more practical and realistic proposition. And then finally, they should have proper surveillance so they know what's going on in the marketplace instead of this sort of ad hoc sort of mess that they have at the moment. Thank you.
All right, thank you both. I'm assuming the questions will just pop up, so I'm not seeing any questions yet. So, audience, any questions? If not, maybe the panelists have any additional comments following each other's presentations.
So, oh, this on 3, or I can just yell. There we go. So no, I just wanted to say 2 things. I agree with you completely, Clive, that the products, what I was saying was that the flavored products are, you know, quote, some of them are illegal, illicit, and we don't know what's in them. I am all for giving that option to smokers because I've seen it way too many times that it really does help them switch. And I also want to say you made 2 other really great points. One is the diversity and the choice is critical to switching. A single product rarely switches a smoker, especially the first time. And when you're in situations when they try the product and it's not strong enough or it's too strong, it's done. Like you almost kind of get one stop shop here to get it right. And so we see that a lot in our studies that it takes time and it takes multiple products to switch the smoker. And so those should all be considered when designing studies to support these applications. And third, also love the idea about the quality of adjusted life to be an indicator for the benefit. We hear all the time, I've quit in a study and I can now walk up a flight of stairs. I can now walk to my car without having to stop halfway and catch my breath. These are real people with real lives, and these products are helping them have a better quality of life.
I wanted to ask really Azim and Jessica something. I find it very frustrating, and it wouldn't be the case in the UK, that FDA's reasoning in the way it's handling its duties is not open to challenge due to this sort of deference that there is to technocratic agencies. it seems so irrational to me and so outrageous what they're doing, the way they're interpreting the duties. I don't buy Brian King's argument that, well, I'm just doing what Congress makes me do, and the Tobacco Control Act makes me do daft things. I just don't think that's correct. I think it is better to do it properly. So I would like to know what the panel thinks are the prospects of changes in the law, maybe through changes to the Chevron doctrine, opening FDA up to more aggressive scrutiny of the reasoning behind its decisions, not just the process that is followed.
Great question. I guess I'll take a first stab at it. But so I guess, we do have in this country, we do have the APA, the Administrative Procedure Act. And that is the statute that requires federal agencies to act in a reasonable manner. And not in an arbitrary and capricious manner. That's a phrase that you hear often in these types of lawsuits. And so that is the way, that is how the companies are able to make challenges, right? Looking at the fatal flaw review, for example, and the way that FDA failed to give, in my opinion at least, I know Jessica, you might have a slightly different take on it, adequate notice to the industry when it made that switch to essentially requiring this randomized controlled study or long-term study to even get into scientific review, right? And if you recall back in the summer of 21, no one was expecting that. I mean, literally millions of applications were either all, I think someone said before, were either all morons or or something was wrong with the policy. But no one was expecting that would be a requirement to get into scientific review. So we're talking about applications, and obviously it's a result of the influx of applications, right? FDA was not anticipating millions of applications and was getting a ton of pressure from public health and Congress to act quickly. Why are these applications still pending? Why haven't we banned Juul and other products that are still on the market? And they reacted by this internal policy to require this new study. And that has been the basis of many arguments in courts that FDA has acted arbitrary in doing that. And of course, again, it's been split. We have a circuit split right now. We have a number of courts saying what FDA did was appropriate, and other courts that are saying it was not appropriate. The FDA acted wrongfully. So again, whether the Supreme Court takes it on, I think we'll find out in the next several months. We might get an answer to that question. Certainly, the Chevron issue is at play as well. That's a different kind of deference, right? I mean, Chevron refers to the courts deferring to agency interpretations of ambiguous statutes. So not necessarily FDA's scientific deference when they are reviewing an application, which again has to be reasonable. But to the extent that FDA's interpretation of the PMTA standard, APPH, to the extent that's ambiguous, we filed an amicus brief in the Loper case on behalf of the industry, making that argument that that Chevron is at issue here, that FDA's interpretation of the statute has led to this de facto flavor ban, right? So there is still room for things to change, and again, unfortunately, it's happening through litigation, and I'm not even a litigator. I prefer not to be involved in litigation, believe it or not, but not through notice and comment rulemaking, right? Not through development of product standards, not through an agency that is willing to actually meet with and work with companies, right? That's another big problem, right? Companies submit massive applications. Right now, the way it's working is if you get in through scientific review, you get one deficiency letter. And if you don't nail every single question the way FDA wants it, your next correspondence is an MDO. Instead of what should be a back and forth, and maybe we have some follow-up questions, and let's have a meeting. Let's try to get you the information that we need, or get us the information that we need to get to an authorization, because these products can help people. We're not seeing that.
So does anyone else here find it ironic that, so I'm going to answer your question, but I go back to the Tobacco Control Act, and is there an opportunity, I'm nowhere near a lawyer, but to change that because I find it super ironic that the products allowed on the market are combustible cigarettes. And we then have all these conferences and sit and talk about the public health. And we talk about how we care about people and wanting to put products on the market that are less harmful while the act allows cigarettes to stay there. So until when? So is there an opportunity to go to the origin of where this all began and change that through legal efforts?
Well, I think that's one of the beware what you wish for things, because I think the politics at the moment, I mean, it depends what happens after, after the election, I guess. But the politics at the moment, I would say, is more inclined to the prohibitionists who will just try and knock things out of the market altogether, than sort of realists or rationalists who actually want to make the reduced risk in the continuum of risk work for public health. The forces behind this are with the people who don't want it at all and just want, like, I don't know, like it was before with smoking cessation medicines or something. So I'm not sure it would necessarily help. I don't know.
Yeah, I mean, I it's probably not likely, and I'm not a lobbyist by any means, but I do think that the solution to all of this is probably with Congress and not FDA. Like some members of Congress actually changing the law and creating maybe a new framework, but I don't think that's something that's really.
I mean, they can change the law. I mean, they did change it for synthetic nicotine.
No, absolutely.
So it's not impossible.
They did it really quickly.
So we do have one question from the audience. What do you make of comments by Dr. King and others that there's no evidence of an illicit market, and how is that compatible with its position on the lack of legal products for sale?
Well, did he really say that? I mean, apart from the 99% of the market that is illicit, he's absolutely spot on. I mean, it's just a ridiculous thing to say. 23 products that hardly anybody uses and are mostly obsolete are what is authorized. Everything else is illegal in various shades of gray, from light gray to dark black. Okay. And that's the market that he presides over. When I asked a question earlier about who's responsible, I really meant him and CTP and how should they be held accountable, because they have raised the barriers to entry so high that almost nothing gets authorized, and therefore they've created an insurmountable enforcement problem that they can't cope with, other than asking for yet more money to deal with that they should not ever be given.
Yeah, I would just say, we keep hearing about this, all these bad actors and players in the industry, and I look at it from a different perspective a little bit. The fact that we had companies submit applications covering 26 million products, to me, is not evidence of a bunch of criminals who are trying to evade the system. These are companies that are trying to comply. They are eager for regulations and a path forward. They don't want to be, considered illicit, drug dealers, right? And they are forced, they may not have the most robust applications, but again, we were dealing with some very compressed timelines, to get those things done. So, the fact that, again, it's almost like, we look at these applications and it's almost like, this is just proof that they're just all bad actors or they're not playing by the rules. I think it's quite the opposite. I think people want to play by the rules. They want to submit applications. They want standards. And again, we're just not getting it. And so again, everything's illegal because the standard is too high to create a legal market.
Yeah, they're not bad actors. They're small actors. That's the reality out there.
I think we're being kicked off.
Oh, okay. Thank you.
Thank you all.
Thank you. I know I can talk about this for a lot longer, so I apologize for cutting it short, but we do have a reception taking place downstairs, so continue conversations then. And thank you all for coming today. See you soon. Thanks.